But in keeping our detentions out of sight, the United States has a big problem that Europe does not have. We don't have an America that can both do our dirty work and absorb our simultaneous criticism to ease our own consciences. While we can pawn off some detainees on local proxies, there is no extrinsic power whose detention needs entirely subsume our own, and who therefore will serve all of our detention needs so that we don't have to, even while we complain about it in public. Europe can have a no detention policy because it knows that the United States will pick up the slack. Nobody, however, will pick up enough of our slack to allow us the same luxury. So we can minimize detention through a combination of prosecution, release, proxies, and predator attacks. We can keep the number of detainees small, at least for now. But at the end of the day, the United States cannot avoid detention entirely, not even under the Obama administration. The Obama administration itself has come to understand that. To protect US security and the security of its allies, the United States simply has to maintain some detention capacity in a world that doesn't believe in the project of detention anymore. And unsurprisingly, developing a detention policy for such a world turns out to be rather hard. So that's the sort of broad problem that the book is looking at, the sort of attractions of denial and the ultimate problem with refusing to answer the question that you by necessity have to answer because it involves a product and a project in which you really, at the end of the day, have no choice but to engage. And then, at the risk of, I hope I'm not, I will read one more excerpt and then I'll stop and take your questions. This is a sort of toward the end of the book, and an attempt to imagine if you buy the idea that we are in a period in which we have invisible costs, but they're actually rather manageable right now. But you also suspect and worry that there will come a time in which those costs will either not be manageable or at least be very difficult once again. So this is an effort to sort of imagine what those circumstances would look like. Construct whatever scenario you like for this next conflict. Use whatever country name suits you. Fredonia will do if you prefer something that doesn't end in Stan. Give the enemy whatever ethnic and religious background seems plausible. You can make it drug cartels and narco-terrorists in Colombia or Mexico if you want to change the subject from the West's confrontation with violent Islamism. The only thing that matters is that enemy forces will be irregulars, hard to identify, and easy to confuse with the civilians among whom they will hide, and that they will fight in the context of some ungoverned territory. What will happen then? For starters, US forces will capture a bunch of people. The vast majority of these people will be fighters of one sort or another, or people directly supporting the conflict. But our forces will, of course, over-capture as well. The need to protect our forces, the fog of war, and the blurry line between combatant and civilian in such conflicts will all conspire to generate a certain margin of error in which some random people will get mixed in with the bad guys. Everyone will know this is happening, just as everyone knows that civilians get killed and injured in military attacks. Yet unlike collateral damage, wrongful detentions will bother us in an ongoing fashion. And that will not be an altogether irrational response, though the injury done to someone accidentally killed immeasurably exceeds the injury done to someone erroneously detained. The dead civilian is no more dead 1 year later than he was on the date of the errant strike. The injury is done, it cannot be undone, and it does not compound with time. By contrast, erroneous deprivations of liberty do grow worse the longer they go on. They can be corrected prospectively, if not retrospectively. The victimization of the innocent detainee, though of a lesser order than that of the innocent person whom we kill, does pay compound interest. As a consequence, shortly after we begin capturing, we will, as a society, begin worrying. Second, we will not avail ourselves of either of the two mechanisms for relieving that worry. The criminal justice process will not be available because the numbers of detainees will be too large and the evidence against many of them too poor, too impressionistic, and too probabilistic to support criminal cases. Importantly, however, we will also not avail ourselves of the out that the laws of war offers. We will not treat all detainees as privileged belligerents or prisoners of war. Third, there will be no government ready, willing, and able to assist us in handling the detainees. The very conditions that give rise to the conflict in the first place will ensure that there is no local government capable of helping. If one exists at all, it will be too weak, too corrupt, and too infiltrated by the bad guys to handle thousands or tens of thousands of detainees. And European partners in the operation, meanwhile, will curiously abstain from this particular aspect of it. If they show up at all, they will show up to do the nice parts of the coalition project, and they will leave all of the nastiest stuff to the United States, and detention will surely fall squarely into that category. Fourth, as a consequence, US forces will use whatever screening criteria they can cobble together, probably based on some combination of local conditions and the lessons learned in Iraq and Afghanistan. And they will end up making imperfect decisions as to whether to hold people based on the perceived threat that they pose at the time. Depending on how many detainees there are, how long we intend to hold them, and how good our information is, we may use a fine or a wide-toothed comb. Either way, there will be errors in both directions. And then, fifth, our forces will have to put the detainees somewhere. We know they will not choose Guantanamo Bay for precisely the same reason that the Bush administration did choose Guantanamo Bay. They will want to keep the detainees out of the reach of US federal courts. They will have to choose a place that is operationally secure, somewhere the United States has near total freedom of movement and answers to nobody else. And then, as night follows day, we will confront the question of whether the chosen facility really does lie outside the reach of the US courts. We will earnestly ask ourselves whether it is more like the United States proper, or more like Guantanamo, where the courts have jurisdiction, or more like Bagram, where the courts, for now, have no jurisdiction, or more like the Landsberg prison, where the courts had no jurisdiction in 1950. The longer we hold people, the more anxious we get about the compound interest that we are paying some of the detainees in injustice, and the more the waning of the conflict transforms serious threats into pathetic victims in our eyes, the more we will second-guess our ad hoc choices, and the more we will move the goalposts on ourselves. We will, to lay the matter bare, have recreated Guantanamo. That is, we will have recreated the real Guantanamo, which is not the facility itself, but the problems that gave rise to the facility, the problems that closing the facility will do nothing to address. Perhaps we will tolerate this new Guantanamo with greater equanimity than we did the first time. These things never traumatize one as much the second time around. Perhaps the world, too, will tolerate it a little more readily, particularly if we have, at the key moment, a Democratic president willing to beat his breast over the matter, rather than a Republican president eager to thump his chest over it. But those are optical differences, not legal ones, and we shouldn't count on them. The point is that we will face exactly the same problems that we faced the first decade of the war on terror, and we will face them again precisely because we refused to adequately address the questions that gave rise to them in the first place. And I'm going to stop there, having gone on too long already, I'm sure, and take whatever questions you have.
We've got mics here and here.
Hi.
Hi.
That was very interesting. I go back longer than you. I got my law degree in the late 60s, early 70s. And the only thing I can think of that we had for preventive detention then was the legally insane, the people who couldn't undergo trials and they just locked them up, and people who were involuntarily committed to mental institutions. At the same time, we were always on the case of the Soviet Union because they locked up people without a trial or with a show trial. And now that's what we say about China. So you said that we had more preventive detention than we recognized before 9/11. I was curious to know what you were thinking of.
Oh, well, so this is a fascinating question and an excellent one. And so one of the things that we do is, because we're very uncomfortable with the idea of preventive detention, so one of the things that we do is we define all the preventive detention that we do as not preventive detention. We call it things like immigration detention. Now, in the immigration context, when you're trying to deport somebody, the immigration law is enormously complicated, but there's all kinds of categories of people in immigration law who you either have the authority to, or sometimes some of them you must lock up. So that's one example. You're correct about the dangerously mentally ill, but there's actually an even more interesting category, which is violent sex offenders who have finished their sentences in prisons. Most states now, or many states, have civil commitment regimes, and the federal government actually has a civil commitment regime for such people. In the criminal justice system itself, and we almost never talk about this as preventive detention, and we should, we have a vibrant system of pretrial detention. Despite a requirement that bail not be excessive in the Constitution itself, the Supreme Court's interpreted that to mean bail shouldn't be excessive if you decide to grant somebody bail. And there's also another system of preventive detention in the criminal justice system, which is that you can lock up material witnesses for reasonable periods of time. And this is a particularly interesting one because the witness isn't even necessarily accused of doing anything more than knowing something that would be of relevance to the grand jury. And if you fear that that person would run away, you can stick him in a holding cell for some period of time to make sure that he's available to the grand jury. There are actually a lot. So at the state level, many states have statutes allowing detention in order to facilitate drug treatment and detention to protect. There are some states that even have detention statutes for drug-addicted pregnant people on a sort of fetal protection rationale. So there's actually an enormously wide array of preventive detention statutes. And that's before you get to the traditional law of war preventive detention regime, which is basically anybody wearing the enemy uniform, anybody who you can kill, you can also capture and lock up for the duration of hostilities. Interestingly, the other great law of war preventive detention statute that we have, which has not been used since the World War II era, allows the detention of the nationals of enemy countries, the civilian nationals of enemy countries. Now, don't confuse this with the Japanese internment, most of which people were not actually Japanese nationals, they were US nationals, different issue. There is a long and proud history in this country, or maybe not quite so proud, of interning and under international law, this was the norm, not the exception, of interning what are called enemy aliens, the people who are simply citizens of the country with which you are at war. And we did that in the War of 1812, we did that in both World War I and World War II. And the Supreme Court upheld it as late as sometime after World War II. So there's a lot more detail on all of those things in the book itself. But the broad answer to your question is that it is a matter of some civic mythology that we don't engage in preventive detention in the United States, and we do.
Thank you.